All right, there we go. Thank you so much. Thank you so much for everybody for joining us for today's webinar. Today we're speaking about healthcare decisions in Queensland and whose decision is it anyway. My name's Sammy Cooper. I'm one of the Sector Sustainability Coordinators at Community Legal Centres Queensland. Firstly, we'd like to acknowledge the traditional owners of the land in which we're holding today's webinar. In Meanjin or Brisbane, they're the Turrbal and the Yagara people. We wish to pay respect to their elders past, present and emerging, and acknowledge that these are stolen lands and that sovereignty was never ceded. As this webinar is being viewed by people across Queensland and indeed Australia, we also pay respect to the traditional owners throughout the country and of course extend a warm welcome to any First Nations people listening today. We're pleased to welcome today Karen Williams and Rebecca Anderson from ADA Law, who will be talking to us about resources available to health consumers, legal and health practitioners and decision makers about the health decision making regime in Queensland and provide improved certainty for decision making. We're also joined by Mandy Shercourt from the UQ Pro Bono Centre, who's going to give you some tips about how you can get in touch and work with them. I'll let our presenters tell you a bit more about themselves when I hand over to them in a moment. And before I do that, just some quick housekeeping. Today's webinar is being recorded and we'll have the recording available to download later on today or potentially tomorrow. The PowerPoints and the other materials have been emailed out to everybody who registered and are available to download from the website and also from the handout section of the GoToWebinar control panel if you're having any problems with that. I do encourage you to ask questions. Today's topic is going to be really engaging and I'm sure that we're all very keen to hear what our presenters have to say. Please type your questions into the question box on the control panel and I'll read your questions out at the end. We will hold them over until the end of the presentation, but of course, please feel free to type them in as you think of them. Our presenters will also be running some polls today and I'll be prompting you through those, so please make sure you put the answers in when they appear on the screen. And I'll hand over to Karen and Rebecca, joined by Mandy, and I'll talk to you again at the end of the session. Thanks very much.
Good morning, this is Rebecca Anderson. I'm here, as Sam introduced, I'm here with Karen Williams and Mandy Shercourt. And then we're going to just try and figure out how we can share our screen. So while we do that, I'd like to acknowledge the traditional owners of the lands that we're meeting on today and pay our respects to their elders past, present and emerging. As this presentation is being viewed throughout Queensland, we also pay respect to the traditional owners of the lands throughout the country and of course extend a warm welcome to any First Australians listening to this presentation. So a legal disclaimer as we begin is that this presentation is for professional development and educational purposes only. The information that we're giving today is not legal advice and is designed for lawyers and other staff working in volunteering in community legal centre settings in Queensland, as well as in health settings in Queensland, and it is specific to Queensland. This presentation and webinar is not to be published or reproduced for commercial purposes without the permission of the authors. And the information is current as at today. And we don't accept, CLC Queensland does not accept any liability for the accuracy of information in the presentation. We're having slight hiccups with sharing the screen, but I will just read another housekeeping notice that the CLC Queensland wants to ensure that the CLC workers and others accessing this information are safe and able to access appropriate and timely support. So some of the content in this might cause some concern or upset for some people, and we respect your autonomy, and if you do feel triggered or upset by any of this content, we encourage you to use your discretion of whether you should continue participating with the webinar. You can also access more resources and professional support through the Keep Safe website, which is listed in the webinar notes. So we think you can see our screen now, and we're just going to skip ahead a couple of slides once we figure that out. There we go. Thank you. Sorry, how many lawyers does it take to work a computer? Okay. So these are the presenters that we have today. So I'm obviously, as I said, Rebecca Anderson. I'm a solicitor here at ADA Law. And I'm joined by Karen Williams, who's the Principal Solicitor at ADA Law, and Mandy Sherkor, who's the Director of the UQ Pro Bono Centre. So I might get each of you to just introduce yourselves and have a quick say.
Okay, thanks, Rebecca, and hello to everyone else out there. Yeah, ADA Law has only been established for a year as a community legal centre, and we're very happy to be part of the network of CLCs across Queensland. My background is that I've worked as a social worker in mental health and emergency departments, etc., as well as having been a lawyer for some time. And basically we support people whose capacity may be questioned in relation to tribunal representations and negotiations with their decision makers. That also leads us down the path of support, looking at people providing assistance and advice in relation to some advanced health directive or enduring power of attorney matters. So that's sort of the bulk of what we do here at ADA Law. Mandy.
Hi, thanks very much, Karen and Rebecca, and thanks for inviting me today. As Rebecca said, I'm the Director of the UQ Pro Bono Centre. I think hopefully many of the community legal centres know what the UQ Pro Bono Centre does, but we, as you can see there, develop, promote and provide student pro bono legal services through partnerships with the not-for-profit sector and in particular with CLCs. And one of the reasons I'm here today is because the UQ Pro Bono Centre worked on the project that is being presented today with ADA Law. So it gives me a great pleasure to be here as part of that.
Thank you both. So we're going to start with a poll, and we might cross over to you, Sam, but we just wanted to get a feel at the beginning of this session of where our listeners are coming from. So if you could just let us know whether you're a lawyer, a health professional, an advocate, a community worker, a student or other, just so that we can have a bit of an understanding of, you know, as we go through this session, where you're starting from and see what space there is. I might just allow a few minutes for you to populate that.
So the poll's up on the screen now. If you could pop your answers in, I'll give you maybe 10 more seconds to pop them in. Perfect, thanks guys. That's majority of the people listening online at the moment. We've got about half of the people listening are lawyers, about 30% are health professionals. We have a couple of advocates, some community workers, and also some students.
Fantastic.
It's quite a good mix, actually. It's quite good to see some health professionals as well as lawyers, because obviously this has gone out predominantly through a legal network, but it's very good that we've got some health professionals on board as well.
Excellent. So we'll just look at what we're aiming to do during this presentation. There's basically a dual purpose. So with the UQ Pro Bono Centre, we've developed some resources to try and simplify the decision-making process for health consumers, legal and health professionals, and also decision makers, which may be family members or supporters, which is the general community essentially, and to try and unpack the health decision-making regime in Queensland and provide some improved certainty for decision-making. So hot off the press, so recent research, as we've noted there in the slides, is showing that only about 33% of Australian adults know about decision-making laws, and in the survey there's only 13% of people reported having acted in the role. So there's a lot of people that either don't know generally about the law or also haven't had specific knowledge of how to act in the role. And Also, it's a great opportunity to showcase how great it is to work with law students in the UQ Pro Bono Centre to help develop these resources and also educate future lawyers of how to make the law more accessible for the community as well as themselves. Okay, so we're aiming to look at not only the decision-making process in Queensland as it currently is, but also through the overlay or important filter of the Human Rights Act, and in the shadow of the Voluntary Assisted Dying Act, which won't come into force until 2023, but it will probably promote some discussion about what decisions can be made now, who can make them, and what difference may Voluntary Assisted Dying Act make. So they're big conversations, but we just wanted to start with, well, what decisions can be made now, and what tools, etc., are out there to help people identify what it is they want to do. So who can consent, and what are the barriers to consenting? When is a capacity assessment warranted? Who conducts these assessments? What happens, if the consumer doesn't understand, or if they weren't able to consent last time? So there's a lot of complexity in this area, in both the decision-making and capacity, and then how does understanding human rights impact on that? So in reviewing the literature, we found that there was definitely a lack of certainty and a reliance on out-of-date practices such as next of kin as a concept for health decision-making. So we're wanting, the purpose of today is to try and provide some simplicity and clarity for these concepts. Okay, so the legislation in Queensland is gradually becoming compliant with the United Nations Convention of Rights of People with a Disability, and people with a disability, that's an all-age concept, so it doesn't, it encompasses all people, older people, younger people, and this framework includes a less restrictive approach that you don't impact on people's ability to make their own decisions unless it's absolutely necessary, and the right to autonomy or your own decision making is to be respected and upheld wherever possible, and this includes in the healthcare sector. And this brings into frame big ethical and as well as legal questions about balance. How do you balance autonomy and dignity of risk and duty of care, all these big concepts. And basically our focus today is just going to walk calmly through the legislation, what's out there in front of us at the moment. So we're going to have reference to the Guardianship Administration Act of Queensland 2000 and the now associated Queensland Capacity Assessment Guidelines, Powers of Attorney Act, Mental Health Act, Civil Liability Act, Human Rights Act, Transplantation and Anatomy Act, and Public Health Act.
To name a few.
Are all relevant, but we won't be focusing on all of those. Okay, so we have another poll about what's your level of comfort, clarity or certainty about healthcare decision making in Queensland.
So do you know a lot? Do you know a bit? None at all, or other? I don't know what other's going to come out with. We'll see. Over to the polls.
Now, there should be some questions, or one question and some answers on the screen at the moment. Give you about 30 seconds to put your answers in. Certainly tell we've got some lawyers in the room. All right, then looks like we're getting close to just about everybody having voted. Give me about 10 more seconds. Okay, so what is your level of understanding of the healthcare decision making? We've got about 75% of the people on the line at the moment know a bit, 18% know a lot, and a few who don't know anything and are very much looking forward to this presentation.
It's probably a better educated crowd than the general population in that space, because most people will know very little. It's not something they turn their mind to. Yeah.
Okay, so I'm just going to take over here and tell a little bit about how the UQ Pro Bono Centre became involved in this project. As I said earlier on, the UQ Pro Bono Centre works with the not-for-profit sector on projects, research projects, developing resources, anything really that the not-for-profit sector wants. And we do that by using students from the UQ Law School who have signed up to be involved in pro bono projects. And from our perspective, it gives students the opportunity to engage in real work and also become hopefully committed to a lifelong commitment, to pro bono legal services. And the collaboration between ADA Law and the UQ Pro Bono Centre came about when the ADA Law contacted us and said that they had this project where they wanted to develop resources, as Karen has said, to simplify the law in this area, or to provide a simplified overview of what can be very complex issues. So we prepared a little position description based on what ADA law were required, and we sent that out to our students on our roster, and then we chose suitable students for the project. ADA Law worked with us by supervising the students, briefing them on the content that they wanted, providing feedback at different stages along the way. And we also met with the students, and I engaged one of our professors, Professor John Devereux, who works in health law, to also provide some assistance and to provide some overview and support. And the students worked remotely, having regular Zoom meetings with the supervisors. We had 5 students engaged in the project overall, and we'll thank them at the end, but 5 students who worked at different stages of the project.
Thanks, Mandy. And I would say as well that, you know, it was a fantastic benefit for us, because we had some concepts, but it was the turning them into something useful when we're obviously always time poor and resource poor, and also the benefit of the students getting to do the research. So we weren't giving them the answers, we sent them off to do the research, and then for their benefit, obviously research skills as well as turning something theoretical into something practical. It was very good.
So the way in which the project developed was ADA Law provided the students with 3 scenarios. And the scenarios are, as you can see there on the screen. We had Maria, who was an older woman who had a fall and was now in the emergency department. She was confused, and there was a proposed hip operation, as I recall, with Maria. We had Abraham, a young man who was involved in a car accident, was unconscious in ED and possibly had a brain injury. And Elizabeth, a long-term kidney dialysis patient who was refusing further treatment. And the students, 3 students, took a scenario each, and they had to work their way through who could make a decision and what were all the possible permutations and combinations that would arise in relation to whether or not the person had capacity, and then what decision that needed to be made.
And the reason for those types of scenarios was that they're fairly typical cases that we see in our legal practice, particularly the older person who's had some sort of health event that sort of brought them unstuck a bit, and now they're in a pickle trying to figure out how to get moving forward. So that's why those scenarios were selected.
And the resources that were developed, the students were asked to sort of work their way through the law, and then when they had done that, to prepare it into a type of flow diagram. So their flow diagrams didn't look anything like this. This is them being now put together into a much more palatable or easy to use format. But yes, they provided some flow charts that we went through to, as you can see there, assist with health practitioners' legal literacy and ensuring that patients' rights were always at the forefront. And after, the project was divided into 2 sections. The first had the 3 students working on the scenarios, and the second group of students came in once that had been developed and looked at it from a human rights perspective, and looked at how sections of the Human Rights Act may influence each step of the decision making.
Okay, so that you can see on the screen another one of the flowcharts. So some sort of suited to different formats. Just depends on the style and how you absorb information, or how your clients might absorb it. So there's a focus on legal requirements and the rights framework, and also basically you'll see in all of the formats there's a section in the middle where we focus on supported decision making, because we thought that was an area that is emerging in practice and difficult to know how that practically applies. But it's essentially, if it's not absolute, the person is their own decision maker. So that's the green there, unless it's an absolute emergency and they're unable to provide consent. Person is their own decision maker and they have capacity. There's no concerns about capacity. They make the decision to consent or refuse treatment. And the next midsection is the supported decision making, which comes up as that sort of amber or yellow colour, and where someone may have a capacity assessment and then that's checked out and they do have capacity. They go back to being their own decision maker up the top there. You're still unsure about capacity, look at what can be done to implement the supported decision-making strategies, and making sure the person's got information that they need to make their own decisions. So what decisions can the person make, and under what circumstances? So the person may lack capacity for some areas, but may be able to make decisions in other areas. So this is a focus only on health questions, which is why we went through the scenario. And then below we have the substitute decision-making framework, and there, to unpack that, it's looking at, is there an advanced health directive that covers the situation that the person's in which case you go with the advanced health directive. Is there a healthcare guardian? Is there an enduring power of attorney for personal matters? And then if not, the statutory health attorney framework applies, which is the default position. And ultimately, in an emergency, it would be a spouse, a carer, family or friend, or ultimately public guardian. And if it's the statutory health attorney framework is unable to work, it may result in a QCAT application being made. But there's just a visual diagram, and these flowcharts will be up on our website, hopefully now or go very soon.
So just the point to make about the statutory health attorney for those who don't know already is that that's the correct term for what was referred to as the next of kin back in the 90s. And some practitioners are holding on to the next of kin, but that's no longer legally valid. It is a statutory health attorney is the correct title. It's broader and it has more practical applications. It recognises a person's support network is broader than just the people that they're related to. So we wanted to make sure that that gets in there as well, so people can have an understanding of that. And I think you'll see sort of from the flowchart as well that it can be quite a circular process. And that's the other point, is that capacity and this decision making is not done once for people. Sometimes this flowchart is re-looked at multiple times throughout an admission.
Okay, so central to all of the decision making is the person themselves. So it's recognising the person's autonomy, and that's where the human rights aspect comes to fully play out in the situation, and also the right to have support to make a decision. That's also part of what the United Nations Convention on Rights of People with a Disability. So the legal framework is to always assume or presume an adult has capacity. So we always come to the situation with that in mind, and that, as previously mentioned, capacity is decision and time specific. And as Rebecca has mentioned, it's a constant question. It needs monitoring, per decision, so that it might be a different decision that's often made next time, or it might be a simpler decision, or it might be more complicated. So like a lot of health issues that get monitored, capacity is another issue that needs that regular monitoring. Providing the adult with support and information they need to make and communicate the decision, that's going to be very variable according to the needs of the person. So that's where the supported decision-making framework comes in. It could be an interpreter, it could be according to the time that people take their medications, or it could be that the information's not in jargon or bureaucratic speak or legalese. It could be making sure the people who might have a sensory impairment, such as a hearing loss or eyesight, that have got the necessary accommodations. And the idea is to assess the adult's decision-making ability rather than the decision they make or made, and respect the person's dignity and privacy, and explaining where people are in the process, which is the transparency point. So these are the resources that you'll see up on our website, and we've sort of shown a few of those, and we've got one in more black and white that's going to be easier to print off for the general community.
Yeah, the first two on the left are the same item, just in one version is in colour, just depending on how people like to see it. So as well as putting these resources, so these are the end product after the semesters with the students and a period of time of going through and so on. So as well as putting them on our website, we're also going to be putting on the students' research. So some people might want to look into the weeds a little bit and see which section of which legislation got us from A to B. So that's going to be available on our website as well. And this project was focused on who can make what decision, but next we're really going to, well, hopefully next we'll look at what decisions they can make. So, you know, with capacity being a resolved issue for someone, can they choose sterilisation? Can they choose voluntary assisted dying? Whatever the question might be. So that's the project we're thinking of for the future, is what decisions they can actually make.
So for the purposes of today, we're just going to focus on the case study of Maria, and we have the flowchart up there as well. So the facts in Maria's situation is that it's not an emergency. The treating team are considering a hip replacement that might be appropriate in a week or so. And the treating team believe that Maria might have children, but they don't have access to their contact details. And but they are aware that Maria's neighbour has been friends with Maria for a number of years. Reports that Maria has not spoken with the daughters for many years. And also that Maria has moments of clarity over coming days. So based on that, just following the flow chart, it's an emergency in that she's taken to hospital, but the actual surgery is not an emergency. So consent will be required. And yeah, so we will look at the next poll question. So
Sure, I can pop that up for you.
yeah.
So using the flowchart, is consent or refusal required? There's only two options there, yes and no. Give you about 30 seconds to pop those in. Me sharing the poll probably just took away the flowchart, so sorry about that.
You thought that too?
Yeah, bit clunky all of
Sorry.
being in different places.
No, don't be sorry. Testing visual memory. All right, you've got about 10 seconds to pop them in. All right, so we've got about 90% yes, about 5% no, and some people who needed the flowchart to try to remember.
Yeah, and that's okay. Like it's just trying to demonstrate how the flowcharts might be useful, and we're struggling ourselves to try and have the flowchart up there and ask the poll questions.
But I think the fact that we got a variety of answers highlights the situation, doesn't it? Because it isn't an emergency, and therefore straight away we should know that there does need to be some consent obtained before a doctor is proceeding with the treatment, or a nurse or any health professional. So, so yes, consent is necessary.
Yeah, so we go back to.
So we're going to move to the next poll question. I'm sorry we've made this clunky.
Question and let them use
No,
it.
not a problem.
Yes.
Yeah. So the question is, we'll go back to the poll, to the flow chart, sorry, whilst while I'm reading out the question, and then we'll have to get the poll screen up. So if Maria's moments of clarity aren't consistently improving, if she remains too confused at the time that the decision needs to be made about surgery, who should be the decision maker if Maria is unable to make that decision for herself? So is it any of her children? Is it the public guardian because we can't find her children? Nobody because consent's not necessary. Is it her neighbour, or don't know? We'll go over to you for the.
I'll just pop that up there now. All right, you've got about 10 more seconds to pop those answers in. Okay, so our answers here are 10% any of her children, 30% public guardian because we can't find her children, 7% nobody, consent's not necessary, 45 her neighbour, and a couple of people who are unsure.
Great.
Oh, that's fantastic. So yeah, basically what's unfamiliar to us using the statutory health attorney framework is that a friend, and supporter can make decisions. It doesn't mean the person's ongoing decision maker. So a statutory health attorney, just because you've been activated and asked to make a decision, doesn't mean you're an ongoing decision maker, because it's a cross-sectional action. So they're available to act indefinitely in the hierarchy, but often people might be a bit nervous about relying on that decision, but the legal framework allows for it and doesn't require a family member.
So how that would look in Maria's world is that given that Hua is the person closest to Maria at the time that's relevant, he would be the person that the treating team would get consent from. So Maria in the first instance, but if they decide that she is too confused and unable to consent, they would then be looking to her next closest person, which would be Hua. So public guardian would be a decision maker of last resort. So we're going to skip on to the next poll, sorry. So again, using that flow chart.
So I'll do the talking while Rebecca manipulates the technology. So when does the decision, so we talked about who is the decision maker, now it's a question of timing. When does the decision need to be made? And so is it while Maria is in the emergency department before she goes on to a ward for proper admission, on her first day in the orthopaedic ward, on the morning of her planned operation, or as she's waiting for the operation to commence? So over to the polling.
How are we going, Sam?
So I'll give you about 10 more seconds. I didn't realise that I was on mute, been chatting away to myself. About 10 more seconds to pop those answers in. All right, so we've got about 20% say before she's transferred, 30% on her first day in the orthopaedic ward, 50% on the morning of her planned operation, and a couple of people as she's waiting for the operation to commence.
Mm-hmm. Yeah, well, the critical factor is that it's consent for an operation. So that's the decision we're wanting a decision on. It needs to be before the operation is the operative thing.
So, for example, on the ward during the week leading up to her procedure, her agreement or other with having the procedure may fluctuate. So that's part of an ongoing discussion that the team will be having with her. But actually giving consent at the relevant time is right at the procedure about to commence time. That's when it's most important that if Maria can't consent for herself, then someone else is doing so. So we're going to go to the last poll question, again, using Maria.
Yeah, so the question is, and looking at the flowchart, when does Maria's capacity need to be assessed? Only when she's admitted to the hospital, once the treating team have decided she'll need the operation, Route Marie's admission, including before all procedures are done. No need, her operation is an emergency, and I'm not sure. So once again, just leave that flowchart up for a second and then over to the polling questions.
I'll leave this up for about 30 seconds, give everybody some time to pop those answers in. Even if you're not sure, pop something in. It'll help us to gauge how we're going. And they're all anonymous.
Thanks for all
Get wrong, it doesn't matter. All right, so we've got about 10% wants the treating tech TT. What does TT stand for? That might have spun.
Treating team.
Treating team.
Treating team, of course it does, Samantha. Listen, once the treating team has decided that she'll need the operation, 85% throughout the admission, and a couple of people who are unsure.
Great.
Oh, that's music to Rebecca's ears.
Yeah, throughout's the winner.
That's right, because she may, rapidly improve, toward the end of her admission, for example, and be quite confused at the beginning. But it's a human rights approach to afford her own decision-making rights as soon as she's able to assert those. So that's fantastic. So basically, what we've been trying to demonstrate through this webinar is how to apply the decision-making framework to fairly familiar case scenario. So, and as we've seen previously, there is a problem that not everyone knows the law in relation to how healthcare decisions can be made, and that's for all of us, the general community, health professionals, lawyers, etc., and private decision makers. We also need to understand the human rights focus and begin to have a practical understanding of supported decision making and what that might mean for an individual. And it always means to include the person in their decisions, even if they're a substitute decision that's being made. It can be quite a difficult concept for lawyers and other professionals, particularly if you think in a binary way that capacity is on or off and the decision's been made once and for all and that type of thing. So it's a lot more subtle and sophisticated. And basically we need to know this because we all might be asked one day to step in and make decisions for others at any time.
And that's consent or refuse. Sometimes we're asked by our loved ones to say no to the doctors, and we need to know what our rights are in that space as well. So some useful contacts for folk wanting to know a little bit more is visit our website. We obviously also do casework for clients and do specific advocacy for people in this space. There's the information on the Human Rights Commission's website. They've got a fact sheet there. Public Guardian also has a statutory health attorney fact sheet. It's old now. They've had it on their website for a little while, but the information is still very accurate and useful. So we'd encourage everyone to get familiar with the statutory health attorney framework. It's underappreciated for how flexible and useful it can be.
Okay, and if you're interested in partnering with the UQ Pro Bono Centre to have very enthusiastic and dedicated and capable law students to work on any projects for your organisation, please do not hesitate to contact me. My details are up there at the UQ Pro Bono Centre. And I'll just do a quick shout out to the students that were involved in this project. A thank you to Gareth, Edbert, Bridget, Johnson and Sarah.
Nice, thank you. So Sam, do we have any questions?
Thank you guys so much. That was so informative. It was really good, really interactive, and a great way to start to engage with some of this content. I haven't got any questions through at the moment, but I will open it up to the floor. If you do have any questions, please feel free to type them in the questions section or also in the chat section. We're monitoring both at the moment, so feel free to send it through to either of those. There's lots of praise, which is nice. Not very many questions. Maybe that means you did do a good job.
So with those deliverable resources, I'd encourage people to think about just printing them off, having a laminated version, you know, particularly around nurses' stations and things like that in hospital settings. It can be an easy flowchart to work through maybe with family and discussing things at the relevant time, and just people getting more familiar and useful with using those resources.
And also the students have put in a lot of thought in relation to how the Human Rights Act applies, and that's can be more difficult to demonstrate as how that concept overlays help decision-making pathway that we've shown you today. So really appreciate that work that's done, but it's more in an essay format, so it's not as accessible, but we certainly wanted to put it up there because just to reflect the huge amount of energy and thoughtfulness that had gone into how that might apply here in Queensland. Take the human rights framework and merge it with healthcare decision making is not easy, but really appreciate the hard work that's gone into that.
Absolutely, it was very thoughtful. We do have some questions coming through. The first one is, can a statutory health attorney make decisions about who the consumer can have contact with while in hospital? I'm not sure who wants to answer that one. Yeah. So can a statutory health attorney make decisions about who? I'll
start. Yeah. So what I often say to people, the clue is in the name, and it's we hear statutory and then I think our brains turn off because it's a three-pronged answer. So statutory health attorney. So it's about health decisions. So the fact that a person is in hospital doesn't make it a health decision. So it's actually quite a good question because we can get stuck with where the person is as opposed to what is the nature of the question. So sometimes in hospital we find, and I'm sure hospital workers can more readily talk to this, is that there's a range of decisions that needs to be made. It might be about, well, who's paying the bills whilst how's the rent being paid or whatever, whilst the person's having a prolonged admission to hospital. That's not a health decision, that's a financial decision. So it's not a statutory financial attorney. And if the person needs to go to a different, needs more support when they leave hospital, they might need services or whatever, a home package, for example. So that's a service decision, it's not a health decision. We're not used to looking at what the question is often. So what you're talking about visitors to hospital is would be regarded as a contact decision. So the statutory health attorney could be part of the person's support network, so you can look at it through the supported decision-making approach, but they're only able to wear the clear health decision maker hat when it's an actual health decision about healthcare treatment. And healthcare is defined in the Guardianship Act, which I won't bore you with that definition right now, but those things are defined. But clue is statutory health.
Wonderful, thank you. Is there an order for substitute decision makers, or is it just the closest individual?
So there is a hierarchy in the statutory health attorney regime in the legislation. So the first port of call is your partner, whether they're your spouse or partner, and same sex is not relevant. It's whoever you refer to as your partner, that's appropriate as your first port of call. And then following on from there is the next ring out, which is family and friends. So your friends are on the same level as your family. I've skipped over one, sorry, which is the unpaid carer. So that might be your close neighbour who also helps you do a fair number of things. They would be considered as a carer for you. Not the same as being a paid working carer. That's a different, not eligible role. So after we have your unpaid carer, then it would be your family and friends, and they're on equal footing. Okay, so that recognises that sometimes people's closest allies are their friends, not their family. And after that, then it becomes the public guardian as last resort. So that's the hierarchy.
Thank you. And that might help to inform perhaps the next question, which is, what is the situation if the patient has an existing health directive, but that person is not contactable for whatever reason?
Okay, so if they've got an advanced health directive, confusingly, it also allows for the appointment of an attorney, but you read the health directive first. So our legislation loves hierarchies, which is good in a way because it provides a fair bit of clarity. So the person's unable to be their own decision maker at that time, you pull out the Advanced Health Directive and you read it, because there might be a written directive in there that applies, and you apply the directive. So it doesn't matter whether the health attorney is contactable or not. It's about the written directive is the priority of that document. So then, you know, you go down the hierarchy. Is there a guardian? Often the evidence of a guardian is that there will be a QCAT order here in Queensland, or there's an enduring power of attorney document, which might be difficult. But if you have the document, there might be other decision makers that are listed in the document as well. So you always need to read these two key documents, the Advanced Health Directive and the enduring power of attorney. And there might be a few people listed in the documents, and the decisions might be able to be made severally. So one of the people might be able to be contacted.
What if they can't be what if there's only one enduring power of attorney and they can't be contacted?
Well, if people can only do what they can do, they can make efforts to try and talk to people. So that's why the statutory health attorney framework is put in place, is to allow people that are nearest and dearest to the person to be able to make the decision. So,
wonderful, thank you. And we've just got one final question, and I appreciate that we're getting close to time, so I will make this the last one. Sorry for anybody who's sending questions through. I might make a note of them and email them through and potentially send them out, depending on what you would like to do. The last question is, what supported decision-making strategies would you expect to see?
Well, it would depend on the person. So a person may have capacity, for example, but have communication difficulties. And often we're reliant on people being able to sign pieces of paper or be able to verbalise. So a supported decision-making strategy might be working out with the person and their supporters. Well, how does this person normally communicate if they're non-verbal, for example? So it's doing that homework. Do people use eye gaze software? Do people not hearing properly, asking, does the person usually have glasses at home or a hearing aid? That's something that they usually use. Who usually goes with them to the doctor? Is there anyone that goes with them to the doctor or helps explain healthcare more broadly? And so there's increasingly, a range of tools that, I'd certainly be keen to look at developing to support people to understand healthcare decisions. But it can be just simply, is the ward too noisy? And the person can't hear properly because there's too much background noise. Think about medication timing. Is the person in pain? Is the person now very sleepy from having some medication, etc. You can see it's so individualised, but it puts you on notice of being a bit of a detective and working out what is support for the person. I often end that by saying support is like beauty, it's in the eye of the beholder. So supportive is what the person themselves considers supportive.
Thank you. Thank you so much for all of those insights. Our presenters, we are so very grateful for you sharing all of your knowledge with us. And Mandy, we certainly appreciate all of the work that you do, and the UQ Pro Bono Centre. I know all of the community legal sector appreciate all of the work that you do as well. And of course, all the people listening for your great questions and engagement. Before you go, I'll remind you to please complete the feedback survey. It'll pop up on your screen once we close the webinar in just a moment. Your feedback, of course, helps us to continually improve the webinar program that we provide here at CLCQ. For now, we hope to see you on the next webinar. And if you have any questions or any comments, you can either pop them in the questions box before you go, or please feel free to email me. Thank you very much, guys, and we'll see you next time.
Thank you.
Thank you, everyone.